in the 7th year for the Court Community Connections, which in terms of Michigan Supreme Court's history, perhaps in view of the history of the world generally, is a very short time. But in a way, this program brings us back to our roots, our origins back in the 19th century, when this court had no fixed location, and the justices traveled by horseback to hear cases. So as John Adams, one of our founders of our constitutional republic, famously said, the United States is a government of laws, not of men. And the founders understood very well what it meant to live under a government of men. They had the experience firsthand of living under a regime where the relationship of the individual to the state and individual rights was not governed by law, but by the dictates of a ruler, the King of England. And that's why our founders created a legal document, the Constitution, that set limits on government and its power and guaranteed specific individual rights. The mechanism for enforcing those limits and rights is the law. We can not truly understand what it means to be a citizen of our constitutional republic unless we also appreciate the rule of law and how it works. So our goal is to leave you better informed about the rule of law and its role in our constitutional republic. And I urge you not to let this experience end when you walk out of the room today or take your final exam in your civics class. Our form of government can only survive if its citizens care enough to stay informed and remain involved throughout life.
Good afternoon. May it please the court, I am Daniel Saylor, and I am here on behalf of the appellant, Allstate Insurance Company. And if possible, I would like to save 2 minutes for rebuttal. Your Honors, I would start by emphasizing Allstate's very slim connection that it ever had with this motorcycle that was stolen in the case. Allstate did not insure the motorcycle, it insured the motorcycle owner's automobile. And this very slim connection was severed entirely when that motorcycle was stolen. From that time on, Allstate's insured had no ability to restrict or control the use of that motorcycle. Anyone thereafter taking possession and operating that motorcycle would do so without the authority of the owner. That much is undisputed. The question, of course, is whether that taking of the motorcycle without the owner's authority is unlawful within the meaning of the No-Fault Act's unlawful taking exclusion. We submit that it is unlawful, and we provide 2 alternative arguments as to why it is unlawful. The first is that because, unlike the felony joyriding statute, the misdemeanor joyriding statute is on its face a strict liability crime. Knowledge is not there in the statute. The required knowledge that the taking was unauthorized is not there. Now I recognize on that first argument that the case law and the standard jury instructions are against me. But if the misdemeanor joyriding statute requires that the taking be knowingly unauthorized, then how is the misdemeanor statute any different than the felony statute, which, unlike the misdemeanor statute, happens to include a specific mens rea element in the statute? Now, my opposing counsel's brief tries to differentiate the two a couple times in its brief to the court. He says that the felony requires that the taker must have guilty knowledge, whereas the misdemeanor says, to be convicted of the misdemeanor, the person has to have intended to take the vehicle knowing that he had no authority to do so. I submit there's no difference there. But the problem is that one statute has the mens rea in there and the other does not. Now, I acknowledge that would I want to be convicted of a misdemeanor joyriding if my neighbor loans me his car and I only come to find out later that it wasn't his to lend me, and I in fact didn't have the owner's authority. I guess I wouldn't like being convicted of that. However, and I'll let the brief speak for itself, but I've laid out the statutory test for when a statutory crime is interpreted as providing for strict liability. And frankly, this meets the test.
You think the legislature intended for a person who is taking a car with the expectation the person giving it has the authority to be liable if it turns out the car wasn't owned by that person but his spouse?
Well, as I say, the case law provides that it is a question of intent, and one of the things you look at is, of course, the text of the statute. And one of the big things is whether or not the statute simply codifies a common law crime, or if it's a brand new...
I know the text, but I'm trying to
Do we
understand what you
think
think in enacting this misdemeanor version. You think the legislature really contemplated that if your neighbor loaned you his car and it turns out that he's not the owner but his wife is, that is a crime? They intended that for that to be a crime.
I can only say that the statute, when you compare the felony and the misdemeanor statute side by side, that can only be the intent. They must have intended one to have a knowledge element and the other not. Our fallback argument, of course, is that even if a person who takes a vehicle without the owner's authority will not be convicted if they had innocent knowledge, so to speak, if they did not know that they were lacking the owner's authority. The question is whether, nevertheless, under the No-Fault Act's unlawful taking exclusion, it is unlawful for purposes of that first phrase of the statute. And I would submit that it needs to be construed that way, that unlawful means any taking that lacks the authority of the owner. Otherwise, 3113A.
I'm concerned. We are talking about the proper construction of a criminal statute. Here, the misdemeanor joyriding statute. And you are attempting to infuse that construction with an entirely unrelated statute, the no-fault, and inform that construction by what the no-fault statute says.
Not exactly.
The misdemeanor statute has nothing to do with innocent taking, or the language of the no-fault statute. Why would that influence the court at all in how to construe the misdemeanor statute?
I'm not suggesting that the No-Fault Act should influence the construction of the misdemeanor statute. What I'm saying is that in the same way that if we accept the proposition that knowledge is an element for misdemeanor joyriding, let's assume that going forward. My first argument is that it's not one of the elements. The second is, let's assume that it is. It's not in the statute, but we're supposing that the criminal law assumes a mens rea element for that conviction. In the same way, a taking can be unlawful under 3113A when it's unauthorized, even though you're not necessarily excluded from benefits because the statute includes the reasonable belief safety valve, so to speak. Under the unlawful, and so now we're construing 3113A and not the misdemeanor statute. And the question is, the court has already said unlawful means not lawful, contrary to law. So the question, is it lawful to take and use a person's vehicle without a person's permission? Well, certainly, again, under the strict language of the misdemeanor statute, the answer would be no, it's not. And as I say, can you be convicted of joyriding if you didn't actually know that you had lacked the owner's permission? Perhaps not. But likewise, as I say, you're not necessarily disqualified from no-fault benefits either if you take a vehicle without the owner's permission.
Mr. Saylor, on page 3 of your application for leave, you accepted that, quote, some element of intent on the part of the actor is necessary for the unauthorized taking to be unlawful. Later on page 11, you said the claimant's knowledge is material, since even though the misdemeanor joyriding statute is only a general intent crime, knowledge of the lack of authority is necessary for a violation to occur. You you now argue that the Court of Appeals has erroneously added a guilty knowledge requirement that is utterly unsupported by the text of the statute, and that we have a strict liability offense. How have your views come to be so seamlessly changed so quickly?
Well, Your Honor, you're correct. On the application, we accepted the proposition of the knowledge element. However, as the court rules provide, a party can move to add issues, and the court on its own can add issues. And the court having done that, we are embracing the argument and making our best argument.
Our order invited you to address that issue.
That's correct. And I would say that under the court rule, that issue is properly before the court because the court can add issues.
Well, which is your real position? The one you used when you applied, or the one that you are using now in response to the request for you to address the issue?
Certainly it's the latter, Your Honor.
Didn't occur to you the first time.
The reasons at this point probably don't matter as to
why.
Well,
they do matter in this sense. I don't know, is it 4 or 3 decades? For 4 or 3 decades, the Court of Appeals has construed the misdemeanor joyriding statute as having some kind of guilty intent within its ambit. That's a fairly significant period of time.
Right.
I bet insurance companies like your client have underwritten policies with that understanding of Michigan law in mind. So there are some reliance interests out there in our society. I doubt that any joyrider takes a vehicle in reliance on that construction, but there are other reliance interests in our society. Why should we disturb that?
Well,
even if you're right, it sounds like a strict liability statute written on its text. Why should the court disturb that body law, particularly since that statute isn't directly in front of us in this case?
I would agree with that. The statute is not, this is not a criminal case. However, if construing what is before the court, of course, is whether this was an unlawful taking within the meaning of the no-fault exclusion. And whether or not, perhaps leaving for another case as to whether a person can be convicted of a misdemeanor joyriding when they're able to show that they lacked actual knowledge, that they lacked the owner's permission. I think that the court can and should construe the unlawful taking phrase of the No-Fault Act, which is before the court, as being any taking by anyone of a vehicle that lacks the true owner's authority. Now, in Spectrum Health last year, the court, a couple different times in the opinion, directly so stated. The court said the phrase, quote, taken unlawfully, close quote, in 3113A applies to anyone who takes a vehicle without the authority of the owner. And then in footnote 25, the court was addressing more specifically whose authority is at issue, and it said, for purposes of 3113A, a vehicle is unlawfully taken if it is taken without the authority of its owner. Now, admittedly, that really answers the case in my favor, but I will concede, of course, that in Spectrum, the person who took the vehicle in that case knew that he lacked the owner's permission, so that issue was not directly before the court. And yet, the court did address our situation in Spectrum, because the dissent had raised the concern, now wait a minute, if you construe unlawfully taken that way, you're going to exclude benefits from a whole class of people who take possession of the car from an intermediate user. And the court said no, because of the second phrase of the statute, the person's still not excluded as long as they have the reasonable belief that they're entitled to take and use the vehicle. And as I say, I believe you should construe the statute this way, because otherwise you violate the rule that prohibits you from writing out part of the statute. And that second phrase of the statute, the safety valve, becomes entirely meaningless and superfluous if you say that an authorized taking...
Within your reserved time.
Oh boy.
Can I ask you one more question, please?
Sure.
The criminal statute in controversy in this case is, I believe, one that can be fairly characterized as not being a public welfare statute, a regulatory offense, or malum prohibitum. It is, in fact, a theft offense, a common law type of criminal activity, and malum in se. Are you familiar with any kind of statute that would meet or match those kinds of characterizations that in Michigan, or indeed outside of Michigan, has ever been characterized as a statute imposing strict liability upon an alleged perpetrator?
Well, not specifically, no. I would say that I would disagree with the idea that this is a theft type crime and that the statute is based on common law. I cited a couple of Supreme Court cases in my brief that recognize these joyriding statutes as an entirely new legislative created crime that came with the onset of the automobile and the emergence of what it described as relatively harmless but bothersome invasions of the property interest in the vehicle owner, where they would take the vehicle, although they're not intending to deprive the owner of it permanently. Those cases suggest that this is a statutory crime not based on common law. And that factor, plus the others that I cite, the fact that other related similar statutes provide meaning to the lack of any mens rea in this statute.
You disagree with my characterizations. For the sake of argument, if those characterizations were reasonable and indeed correct characterizations, would you have more difficulty with this case than you do in this juncture, apparently?
I think that my initial argument, my first argument, is a difficult one to make because the statute does not seem to be, regulatory in nature in terms of the types of statutes that are construed as strict liability, like pollution laws, or there was an old one regarding keeping your tavern closed on Sunday and things like that. I know I'm out of time. If I have any time for rebuttal, I will make my last point there. Thank you very much.
I represent the plaintiff appellant, Lejuan Rambin. I'd also like to just say it's a real pleasure to be here today, and I'm really glad to be in the presence of everyone who's so interested in our Supreme Court and our judicial process. Thank you. Of the two questions the court asked in its May 1st mole, where the first addresses the legal standard of how we determine an unlawful taking, particularly in these facts, is there a knowledge requirement? And there clearly is. I believe that the court just last year in Justice Sarah's decision, in Spectrum Health, resolved the issue definitively and held that determination of an unlawful taking under the No-Fault Act, Section 3113A, rests on whether or not there is a violation of the Michigan Penal Code. The decision was resolved. I also think if you look at the plain language of the statute, it says taken unlawfully, not taken without consent or taken without permission of the owner. And I think that the Allstate's position here is an attempt to rewrite the unambiguous language of the statute. The defendant argues that there's no purpose for the misdemeanor statute if there's a knowledge requirement, and that just is untrue. The misdemeanor statute and the felony statute are companions. One is a felony provision requiring willful intent. One is a misdemeanor provision that does not require a willful mens rea, but still requires a mens rea of knowledge. And in the Hayward case, the Court of Appeals explains very well the functional difference between the two statutes. Hayward talks about the difference between just going up on the street and taking a vehicle that you have no connection with whatsoever, and you have absolutely no authority connected to the vehicle, versus taking a vehicle that you may have had prior authority to take. Or, for example, if I loan you a car and say you can use the car for this day, but bring it back tomorrow, and you use it for the day, but then don't bring it back for 2 or 3 more days, that is a violation of the misdemeanor statute, because you are using the vehicle with knowledge that you've exceeded the permission. So there's knowledge, but it's...
There's no textual support for that argument. It says simply any person who takes or uses without authority, without intent to steal. There's nothing in the text that it seems to suggest you have to have specific knowledge of that you're taking without authority.
Yeah, Chief Justice Young, you're right. I mean, the statute does not include the elements, but as this court has frequently acknowledged, the legislature, in numerous instances, passes criminal statutes that do not include the requisite elements of the crime. And this would be one example. And so what we would have to do...
How do you distinguish between a statute that says take without authority and one that says take willfully without authority?
There would still have to be... There is
What's
a difference.
The difference
is...
If the misdemeanor one that says simply take without authority has a guilty intent, how do you distinguish that from the felony?
The difference is that the felony statute is a specific intent crime, requiring that there be a showing of that you subjectively intended the illegal purpose. The misdemeanor statute is merely it does not have a willfulness, subjective, specific intent requirement. It requires only that you take it and that you know the taking exceeds the authority.
Mr. Focus, the Chief Justice said that the statute says willfully without authority, but what it really says is willfully and without authority. Does that make any difference?
It does. I mean, again, there's the felony statute has a subjective intent mens rea requirement. The misdemeanor statute is a companion to and a lesser included offense.
But I heard all that already. I mean to be asking the question, willfully, it seems to me, doesn't modify without authority.
It's an addition.
It's an addition. So what does willfully modify, and does that help us with the question we're trying to decide?
That's a good question.
Thank you.
That's a good question.
That's a better question.
I think only the judges laughed behind me. I don't know if the students did. I think that the taking is willful. I think that is what it modifies. And again, I think it relates to the specific act of what is in the mind of the person who takes the vehicle at the time.
Well, if you're right, then we might impose, or as the Court of Appeals has done for some decades, a mens rea requirement on the without authority clause, assuming that the willfully modifies the taking. Sounds like that's what you're saying.
Correct. Well, and let me just emphasize this too. And these were questions that Chief, that you asked. This has been on the books since 1948. There are cases since the 50s that have interpreted and have applied the knowledge requirement. A Westlaw search reveals over 70 cases. Now, I know that in and of itself is not conclusive, but this is an enormous implication of what Allstate is arguing here in an attempt to not pay no-fault benefits to this one person who borrowed a motorcycle believing he was borrowing it from the actual owner. This will have implications to the interpretation of the penal code. And let me just say this, if the court is seriously entertaining launching into this analysis and looking at the knowledge requirement in 750.414, I at least would suggest that a MOA may not be as thorough a mechanism to deal with this. Maybe the court should grant leave and get briefing from interested people in the arena of criminal law.
Well, maybe we would grant leave if you were to suggest some possible way of getting out what seems to be, from your perspective, a quandary. I mean, isn't it statutory interpretation 1? You've got two statutes that you yourself acknowledge are companion statutes. They're largely identical, with the very glaring exception of the word willfully.
Right, but
statutory interpretation 1 says what under those circumstances?
Well, statutory interpretation 1 is you go by the wording of the statute. Statutory interpretation 1 also says is that you have to effectuate the legislative intent. And
other than reading the language.
Well, if the language, what you would have to do, Your Honor, to leap to the conclusion that the omission of elements in 754.14 means that the legislature intended this to be a strict liability provision. And just a year ago in Quinn...
Wait a minute. I mean, again, the statute says what it says.
It does. But
so it's not a leave. They didn't actually say.
No, but it's a leave because I don't want to interrupt you. Never interrupt a judge. So, did you want to ask me something else?
No, I said they didn't say, they didn't supply a specific mens rea.
They did not.
And so we have to impute that. And
You have
the
to impute it.
justification for that is?
The justification is the way the court has looked at criminal statutes that do not include elements or mens rea requirements and have done so, the court has done so for years and years, including the Quinn decision just last year, looked at this issue and said when we don't have, when a criminal statute lacks elements or a knowledge or mens rea requirement, it is normally the case the court will impute such a requirement unless certain requirements or certain elements are
Yes, and you're correct about that. Those cases stand for the proposition that will impute a mens rea where the statute is otherwise silent. Doesn't the companion statute here basically communicate that there shouldn't be any silence viewed in the second statute, but rather there's a negative pregnant that's directly drawn from the fact that there's a companion statute that isn't silent?
No, because the statute merely, the felony statute just uses the word willfully. It doesn't, if the statute had said with knowledge and the companion did not, there would be a distinction. But the felony statute talks about a subjective criminal intent, an intent to do that act. And again, the way Hayward talks about it, it's the distinction between just taking something off the street knowing you have no connection with it versus exceeding the authority of use given, which is what we have here. I wanted to point out something very important.
Before you do that, Mr. Fulkerson, even if you could get past the taken unlawfully, how could you respond to the last point made by Mr. Saylor concerning the savings provision, the reasonably believed? How could your client reasonably believe that he was entitled to take and use the vehicle when he had no license nor a motorcycle endorsement?
First of all, you don't get to the savings provision unless there is a determination as a matter of law that there's an unlawful taking. And what we're looking at here is an issue of what is the standard for and has there been an unlawful taking. You don't get to the savings provision unless there's a determination that there's an unlawful taking. And then you say, okay, but then does an exception apply? Now, many members of this court have expressed an opinion that driving without a valid license does not meet a reasonable belief that you can use a vehicle. And I recognize that. Although there have been arguments to the contrary that you don't really look at, that's not how you really look at the issue of reasonable belief to use. You look at the scope of authority or whether or not there are mitigating circumstances of how you can use the vehicle.
You said the way that you look at this is whether there's an initial determination about unlawful taking.
Right.
Before you get to the secondary question of whether there's a reasonable belief. The thing that impresses me is that there was a finding on the unlawfulness by the trial court. What was it? Well,
what the trial court found was based on Merisher versus Plum, right?
What did the court say?
The court said there, as a matter of law, there was an unlawful taking.
As a matter of law?
Yes. Because
I
if you
refer you to the appendix where that is all laid out.
I know.
In fact, your own brief.
I know. You're looking at the trial transcript. And what Judge Borman did was she said, I have to follow Plum and I find that there was an unlawful taking. At the end of her decision, she makes a reference to the fact that she sees a fact question and then didn't believe that there would be a reasonable belief.
I think the trial judge arguably got to the second question about the reasonableness of the belief, having found that there was a question of fact as to the unlawfulness of the taking.
The way the case was proceeded on appeal was that...
I don't care how it was proceeded on appeal. If the trial judge found, as she said, there's a question of fact on the unlawfulness, but I believe your client did not have a reasonable belief. And on Plum, you're done.
I know that there was a language in that one point of the trial transcript, but let me say this, Judge, Chief Judge, Justice, you're not a judge.
It doesn't really matter.
If Judge Borman had said, I'm not ruling on an unlawful taking, but I'm only ruling as to the exception, that's an improper analysis.
Yeah.
You don't get to the exception without making a finding.
I understand that, but again, we're here kind of, because when it got to the Court of Appeals, they sort of ignored what the court actually said and decided the fact question differently. They said there wasn't any material fact question as to the unlawfulness.
Which was also the way it was argued.
I don't care how it was argued. Under the standard, neither party is entitled to summary disposition under C-10 if there are material issues of fact, right?
Correct. And
let me just ask the question. The deposition of your client was in the record, was it?
Yes.
Are you saying that no reasonable person, no reasonable juror, could look at your client's story, which includes, I went to a fellow biker's house with another biker, he gave me the motorcycle, the key fit, I wrote it, I don't know where the guy lives, I never talked to him since, I lied to the police, that no reasonable juror looking at that could say that your client had a credibility problem as to the assertion that he took this motorcycle with authority?
Yes, that is my position based on the fact that there was
no reasonable juror.
No, there's never been any other testimony to rebut the plaintiff.
I understand.
Right. And the police report is hearsay.
Just a minute. I'm looking at the deposition testimony. I'm saying, I'm putting to you the question whether this isn't a credibility question. Whether your client's story is worthy of belief by a jury. You're saying there cannot be any question that my client is telling the truth.
I'm saying that based on the way it was presented.
No.
There cannot.
Okay.
Now, I need to say just two things very quickly. I know my time is up, and you can tell me to sit down. One, the argument that the misdemeanor statute is not a theft statute. In Haywood, it said it was a dishonesty statute, and that it can be used for impeachment under 609. Two, a conviction under 750.414 is a Class H felony under the sentencing guidelines. It is a felony, and it can be used for the purposes of increasing someone's sentence under the sentencing guidelines. And so it is clear that the legislature intended it to be a knowledge requirement, non-strict liability type of statute. That had not been pointed out to the court, and I thought it was very important that the court know this.
Mr. Fulkerson, am I correct that the trial court based its determination that plaintiff was driving his motorcycle unlawfully solely because he didn't have a license?
I don't think so. The court said several times, I'm relying on Plum. As a matter of fact, when the parties started to argue, Judge Borman said, I've read the briefs, and the defendant's motion is well taken, Plum applies. I am applying Plum. And Plum had a chain of permissive use standard, which was essentially a strict liability standard. And otherwise, why would we be here? If the trial judge had said that there was no unlawful taking, that it's a fact question, then the case would have just gone to trial on that issue, and you would have never gotten to the exception. I mean, we wouldn't be here otherwise, unless Judge Borman said, as a matter of law under Plum, there was an unlawful taking, and there's no PIP benefits. And it went up on that basis.
Well, not having a license really has nothing to do with taking, does it?
Correct. It has nothing to do with it. And again, you only get to the exception if you determine there's an unlawful taking. And if Judge Borman had said there's no unlawful taking, it's a fact question, you don't get to the exception.
He comes up to the second part, referring to the no fault. I agree, there's an issue of fact as to the unlawful taking, but as to the fact that he had a suspended license and knew he couldn't drive, the motion needs to be granted.
I know she said that. You're absolutely right.
You just want me to disbelieve my...
I don't, but what I'm saying is that that is just legal, that's just a legal error.
It might be a legal error for her to be applying the savings clause to unseat his right to benefits, but she actually acknowledged there was a fact question as to the unlawfulness of the taking.
She said that, you are correct. But then she went ahead to say, under Plum, I'm dismissing.
Thank you.
Thank you very much, Derek.
Are there any questions? Thank you. The case is submitted. And so is the Republican. Thank you.